I want to welcome you all. Thank you for joining us today for our Paid Family Leave Employer Q&A webinar. I'm Adam Rossi from the Communication and Outreach Unit here at the Workers' Compensation Board. Joining me today is Courtney Valley from our Office of General Counsel. And today we will be providing you with a brief overview of paid family leave, and we will then review some of the most frequently asked questions we've received from employers. And then we will spend the rest of the time answering any additional questions you may have. We will be using the chat feature to receive your questions today. You can enter your questions at any point today using the chat box, which is located on the right side of your screen. We will hold off till the end of the presentation to answer any questions you may have. Courtney will be answering your questions today. She will answer as many as she can, but if you have questions that we either don't get to today, or if we think of something after the session ends, we will be providing you with resources at the end of the presentation. We will also be providing a copy of the slide deck and a recorded version of this webinar. Just make sure you're signed up for email updates so you're notified when those are available. If you are not signed up for email updates, as I mentioned, we will have resource information at the end, which will include how you can sign up. Also, your name and email were given to us when you signed in today. However, if you have a specific topic you'd like to discuss more deeply, please share that topic along with contact information so Courtney can follow up with you, or if it's not PFL related, we can find the appropriate board staff to follow up with you. The chat settings are set so that only panelists can see your questions or comments that come in, so you don't have to worry about others seeing your personal information. Only Courtney and I can see the questions that are coming in. All right, so with that, we are going to go ahead and get underway here. So over the years, paid family leave benefits have been significantly enhanced to further improve the lives of working New Yorkers and their families, including providing more time off, more uses of paid family leave, and more financial security. 2023 specifically brought the expansion to cover siblings for family care, a higher weekly benefit amount, and a lower employer contribution rate. With these changes, we understand employers may have questions. So, today's presentation, we will again provide a brief refresher on New York's paid family leave, including what's coming for 2024. Review the top most frequently asked questions from employers about paid family leave, and highlight the many resources available to you. And as I said, we will take the rest of the time to take any additional questions you may have. So to start, we'll just go over a couple basic things about paid family leave. Paid family leave is insurance, which is fully covered by employee contributions collected through a small payroll deduction. This critical benefit provides job-protected paid time off to employees who need time away from their jobs to bond with a newly born, adopted, or fostered child, care for a family member with a serious health condition, or assist a loved one when a spouse, domestic partner, or child or parent is deployed abroad on active military service. Under legislation signed into law in March of 2020, paid family leave also provides paid time off and job protection so employees can care for themselves or their minor dependent child when under a mandatory order of quarantine or isolation due to COVID-19. The order must be issued by the state of New York, the Department of Health, local board of health, or any government entity duly authorized to issue such order due to COVID-19. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2023, the New York State average weekly wage is $1,688.19. So that means the maximum weekly benefit for 2023 is $1,131.08. This is $62.72 more than the maximum weekly benefit for 2022. It is important to note that employees can take this paid time off all at once, or they can take it intermittently. However, it must always be taken in full day increments. As I mentioned earlier, paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is subject to change by the New York State Department of Financial Services. In 2023, the payroll contribution is 0.455% of an employee's gross wages each pay period. Maximum annual contribution is $399.43. This is $24.28 less than in 2022. Employees earning less than the current New York State average weekly wage of $1,688.19 will contribute less than the annual cap of $399.43, consistent with their actual wages. Now, since we only have a couple weeks left in 2023, we do have some information regarding some changes in 2024. And the New York State Department of Financial Services did recently announce that paid family leave updates for 2024 will be some changing. So beginning January 1st of 2024, the maximum weekly benefit will be increasing again from $1,131.08 to $1,151.16. Meanwhile, employee payroll contribution rate will be decreasing again to 0.373% of an employee's gross wages each pay period, capped at an annual maximum of $333.25. If an employee earns less than the New York State average weekly wage, which for 2024 will be $1,718.15, their annual contribution will be less than the cap. And as I said, employers may start deducting at this new rate as of January 1st of 2024. As I also mentioned earlier, we do have two additional uses of paid family leave that took effect under emergency legislation enacted in response to the COVID-19 pandemic. Depending on the size and type of the employer, the legislation provides benefits for either paid sick leave or a combination of New York paid family leave and disability benefits if an employee is under an order of mandatory or precautionary quarantine or isolation due to COVID-19. This is the only time that employees may receive both paid family leave and disability benefits at the same time. This also gives employees access to paid family leave if their minor dependent child is under an order of mandatory or precautionary quarantine or isolation due to COVID-19, up to a maximum weekly benefit of $840.70. So now let's go over some of the most frequently asked questions we've received from employers regarding paid family leave. Our first question: are employees who work outside of New York State eligible to take paid family leave? In order to be eligible for New York State paid family leave, an employee must be in the employment of a covered employer. To be in employment, an employee's service must be localized in New York State, which essentially means that the employee works entirely or mainly in New York State. This is mostly based on where an employee works. So they might live out of state, or the employer could be headquartered out of state. But an employee who works in New York State is most likely considered to be in employment. Localization is a very fact-specific determination, but we do have a test and some factors considered, which are in sections 2016B and C of the Workers' Compensation Law. Our next question: must employees expend all other leave types before becoming eligible for paid family leave? The answer to this is no. Employers cannot require employees to use paid time off while on paid family leave. Employees cannot collect short-term disability and paid family leave benefits for the same period of time. Again, unless it's the COVID-19 quarantine leave, but that's a separate matter. So a birth mother can, for example, take short-term disability if she qualifies and then paid family leave. It's also important to note that the total amount of time taken for disability and paid family leave cannot exceed 26 weeks in any 52-week period. If an employee has an event that qualifies for leave under both FMLA and paid family leave, and you as the employer are covered under both laws, you may require the employee to take the leaves concurrently. In order for the two types of leaves to run together, that is FMLA and PFL, you as the employer must notify the employee that their leave qualifies for both FMLA and paid family leave, and that it will be designated as such. Our third question: if an employee's leave reason is covered under FMLA and paid family leave, can the employer require the employee to take paid time off at the same time? And the workers' compensation law does not allow employers to force employees to use accruals, such as vacation or PTO, during paid family leave. However, the paid family leave regulations allow an employer to charge accruals in accordance with the provisions of FMLA when FMLA and paid family leave are running concurrently. FMLA, again, please remember this, FMLA is federal, and the board does not have jurisdiction over federal law. We recommend that employers do not require employees to use accruals when FMLA and paid family leave are running concurrently. Question 4. If an employee has exhausted FMLA, does paid family leave grant them an additional 12 weeks of leave? An employer may require an employee to use paid family leave concurrently with FMLA, as we discussed. If an employer notifies an employee that a period of FMLA also qualifies for paid family leave, and the employee fails to apply for the benefits, the employer and insurance carrier may count the FMLA time against the employee's maximum paid family leave. If an employee uses FMLA for an event that doesn't qualify for paid family leave, then the employee will still have that paid family leave available. Our fifth most asked question: can an employee opt out of paid family leave if they work over 20 hours per week? Paid family leave coverage is not optional for eligible employees. Employees can waive coverage if they regularly work fewer than 20 hours per week and won't work 175 days in a year, or if they regularly work 20 or more hours per week, but won't be in employment with that employer for 26 consecutive weeks. So seasonal workers are a pretty good example of this, since they may work full-time, but they're only working for 3 months out of the year, so they would be eligible to waive coverage. If the employee meets the criteria for waiving coverage, the employer must provide them with a waiver form, which you can find on the Paid Family Leave website at paidfamilyleave.ny.gov. Employees who properly file a waiver will not make contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of the employee's waiver on file. Our next question: is there an employer match fund for the payroll deduction, or is this solely funded by employees? Paid family leave is fully funded through employee contributions. Each year, the Department of Financial Services sets the employee contribution rate to match the cost of coverage. As we reviewed, as of now, the payroll contribution is 0.455% of an employee's gross wages each pay period, and the maximum annual contribution is $399.43. However, just keep in mind that that will be changing in 2024 and will be decreasing. So just remember that as of January 1st. If an employee earns less than the statewide average weekly wage, they will contribute less than the annual cap, consistent with their actual wages. Question 7. Can an employee take paid family leave more than once a year due to unique qualifying events? So an employee may choose to use paid family leave for more than one type of qualifying event. Employees may take up to 12 weeks of paid family leave in every 52-week period. An employee who has multiple qualifying events within that 52-week period will still be limited to 12 weeks of paid family leave. And the key number here is the key term here is 52-week period. So it's a rolling calendar, not a calendar year. Question 8. What is the process for submitting paid family leave request forms? Employees should provide employers with 30 days advance notice of their intent to use paid family leave if it's foreseeable. Employers should have forms available for employees. Employees must fill out Part A of the request for paid family leave, which is Form PFL-1. Employers must complete Part B and return it to the employee within 3 business days. If employers fail to return the form within 3 business days, the employee can submit the form directly to the insurance carrier without the employer information. Question 9. Are siblings covered under paid family leave for family care? And the answer is yes. Governor Hochul signed legislation on November 1st of 2021, expanding paid family leave to allow caring for a sibling with a serious health condition. This includes biological siblings, adopted siblings, step siblings, and half siblings. The legislation went into effect on January 1st of 2023, but please check with your insurance carrier for details on when this went into effect for your policy so you can communicate that to your employees. Question 10. How should employers address COVID-19 sick pay, paid sick leave, and paid family leave? Employers are required to provide a certain number of hours of paid sick leave depending on the size of the employer. When an employee is under an order of quarantine or isolation, an employer may be required to provide COVID-19 paid sick leave depending on the size of the employer. This is separate from regular paid sick leave that the employer must provide. Some employees may also have paid family leave benefits available to them. Question 11. When does the COVID-19 quarantine leave law expire? The New York State legislation that provides benefits for COVID-19 quarantine leave does not contain an end date. And our last question, question 12. Is there any recourse if you suspect an employee is abusing paid family leave? If an employer believes an employee is abusing paid family leave, the employer should immediately contact their paid family leave insurance carrier to notify them of the situation. Paid family leave insurance carrier will then determine whether the employee's paid family leave benefits are affected. So as we continue working closely with employers to ensure that paid family leave is being used successfully throughout New York State, we do have several resources to help. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources, including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, and information about COVID-19 quarantine leave benefits. There is also a special updates for 2024 webpage available at paidfamilyleave.ny.gov/2024 with a number of employer resources to help explain and communicate benefit and deduction changes, which again, remember the benefit is actually increasing and the deduction rate is decreasing again this year. So you want to make sure to check out that page to get the numbers and to communicate that to your employees. Other resources that are available on this page include some FAQs, updated model language for employee materials, an employee notice of paid family leave payroll deduction template, and a statement of rights for paid family leave. Employers and employees can also contact the Paid Family Leave Helpline at 844-337-6303 for assistance Monday through Friday from 8:30 a.m. to 4:30 p.m. If you are not already subscribed for email updates on paid family leave, You can subscribe by clicking Get Updates on the bottom of the paidfamilyleave.ny.gov homepage. And again, we will be emailing you updates regarding future webinars, as well as when the copy of this slide deck and a recorded version of this presentation are available. So make sure you are subscribed to email updates so you know when all that is occurring. Finally, we want to make sure you're aware of the board's Advocate for Business. The Advocate for Business is the liaison between New York's business community and the Workers' Compensation Board, giving employers one place to contact for answers to their workers' compensation questions, as well as any questions employers may have about paid family leave as it pertains to your business. You can contact the Advocate for Business office at advocatebusiness@wcb.ny.gov. We hope you found this presentation helpful, and at this point, we will now answer any questions you have. Again, just if you have any questions, feel free to type them in the chat box. I see we do have a few questions that have already come in. I'm going to put our helpline and homepage up there on the screen, so you have that if you want to write it down. Again, I know there were some updates for next year that were on previous slides, so again, make sure you are signed up for email notifications so you know when this recorded version and the slide deck are available. If you need a resource now, again, go to that 2024 updates page, or we have a previously recorded employer webinar that includes the 2024 updates on it. It's either on our Paid Family Leave website, if you go to the webinars page, or you can also go to our YouTube page, search for Paid Family Leave videos on our page, and you can find it there as well. Again, I also want to reiterate, if you have a question that you'd like to discuss more deeply with us, feel free to share your contact information, so your name and your email, so that we can follow up with you after this webinar. But at this point, I'm going to hand it over to Courtney because I see we do have a few questions that have already come in. So I'm going to let her take a look, and she'll be back with you shortly with some answers. Thank you.
Thanks, Adam. The first question that we have here is, can an employee take PFL to travel from the United States to another country with their eligible family member to provide care for their serious health condition while out of the country? And the answer is yes. So you are not required to be in the United States in order to take PFL. You can travel out of the country to take PFL. The only caveat to this is if you're caring for a family member with a serious health condition, you do have to be in close and continuing proximity to that family member while you're taking PFL. So the employee does need to travel and be with the family member who has the serious health condition to provide care for them, but it can be taken outside of the country. Okay, next question here is, can a mother take STD and NICEF disability leave simultaneously? So I think probably here we're asking about statutory disability and some kind of other disability leave. And the answer is that it's going to depend on the terms of that contract. So like if the employee bought their own disability insurance, if they have a different employer insurance, they may be able to take them at the same time. They may not be able to. Very, very fact specific depending on the terms of the policies. Okay, localization question here. Can an employee who lives in Georgia but works remotely for a New York State employer, the employer only has business in New York, be eligible for PFL? So I can't provide legal advice, so I'm not going to be able to give you a yes or no answer, but generally speaking, in order to be localized in New York State and therefore eligible for New York State PFL, the employee has to work in New York State. So if they solely work in Georgia, they're likely not going to be considered localized. But it's section 201(6) of the workers' compensation law if you want to kind of look at the factors for yourself. But generally speaking, it is not where you live, it's where you work that matters. And if you work out of state, you are likely not localized in New York State. Okay, next question here is, what if the event is foreseeable, but they did not provide 30 days advance notice? Are they still able to apply for PFL and eligible to apply for PFL? So the employee doesn't lose their eligibility if they don't give advance notice, but if the event is foreseeable and they fail to give adequate notice, the carrier can issue a partial denial for up to 30 days, depending on how much notice was. So if it was like 15 days, but it was foreseeable, so they should have done 30, the carrier could issue a partial denial for 15 days, or if they gave no notice at all, the carrier could issue a partial denial for 30 days, things like that. Next question here is, we have employees who abuse PFL annually and call out regularly with no notice for intermittent leave. What are our options? So when an employee is not giving adequate notice, if you believe that they're not giving adequate notice for intermittent PFL, you can require notice before each day of intermittent PFL, and if they fail to give you notice, what you believe to be inadequate notice, you should be contacting your disability and PFL insurance carrier, because they are the ones that are going to process and pay or deny the request for PFL. So like we were just talking about, if the employee should have given notice and gave inadequate notice, the carrier can issue a partial denial. So if it's an intermittent leave day that they gave no notice for, but it was foreseeable, for example, and you do require them to give advance notice, you can contact the carrier and they could issue a denial for that day.
Hey, Courtney, I see someone who they missed one of the questions. I guess they're having some computer issues. So could you just briefly touch on or review, is there an employer match fund for the payroll deduction, or is it solely funded by the employees?
So PFL is funded by the employees. So the amount that you can take from your employees is going to match your PFL premium. So every year, the Department of Financial Services puts out the rate for contributions. You are entitled to take contributions from your covered employees at that rate, and that rate is going to match what your PFL insurance policy premium is. So it is entirely funded by employees. You're free to pay on their behalf if you want, but it is not required. It is fully funded by employees through those employee payroll contributions. Okay, next question here is, my parents are 85 and 86 in Florida. My father was hospitalized. I needed help at home, and now my mother is being hospitalized. I have to go down there to help my dad. I would like to apply for intermittent leave because it looks like the events can happen again. How do I put down dates because I don't know them? And do I need to resubmit if there's a need for my other parent in the same year? So first, there is a section on the PFL application that you can check for dates are estimated. And then you would contact the carrier every time you take intermittent leave. And if you have additional questions about this, you're going to want to talk to the carrier, because I think some of them may just require like a quick email. They may require a phone call. I'm not, it may depend on which carrier. So I would talk to the carrier for exactly how you do this. But there is a checkbox that you can put, the dates are estimated. Here's when I think the dates are estimated. If you're going to take leave for your other parent, yes, you are going to need a different application, because the healthcare provider certification is obviously not going to cover your other parent. So if both parents have a serious health condition and you think you may need to take leave for both of them at different times, those are two different qualifying events, and so two different applications, two different healthcare provider certifications, all of that stuff. So they are two completely separate things. The other thing to keep in mind is that you are subject still to the maximum. So it's 12 weeks in a 52-week period, and that is regardless of how many qualifying events you experience. So it's 12 weeks for any qualifying events. Even if you have 50 qualifying events, you're still going to be limited to the 12 weeks. And one other thing I wanted to mention about this is, like we were just talking about, your employer can require you to provide notice before each day of foreseeable leave, but before each day of intermittent leave. So if it's foreseeable, obviously you have to do the 30 days notice. In this case, it may not be foreseeable. You have to provide your employer as much notice as possible before each day if they require notice before intermittent leave. Okay, next question here is, our business is required to provide and have employees sign the employee notice of paid family leave payroll deduction for 2024. So this payroll deduction notice is not a requirement in the PFL law, but we do strongly recommend it so that your employees are fully informed. And please also keep in mind that you are required to have written guidance and information about paid family leave. And on our website, we do have examples of that. You can include this in there, but just keep in mind you do have to have written notice, but the specific notice of paid family leave payroll deduction for 2024 is not required by the law. Okay, next question here is, can an employee take PFL for a full month and then intermittently thereafter for the birth of his child? And the answer is yes. If an employee is eligible for PFL, they are generally going to be able to choose whether and when to take PFL. So if they want to take 4 weeks of continuous leave and then they want to do it intermittently, they can do that. If it's the birth of a child, and so the expected birth of a child, they know when the child was born, they've taken the 4 weeks, they do have to give you notice. But yes, generally they can choose whether or when to take PFL. For bonding leave, it has to be taken and completed within the first year of the child's life. Okay, next question here is, what about the burden to the employer when an employee takes 3 months off every year? So I understand your frustration. the law allows the employee to take a maximum of 12 weeks in a 52-week period. So that's set in the law. It's not something we can change by regulation. So unfortunately, that is what is provided under the law. Okay, next question here is those who work remotely out of state, should they then fill out an exemption for PFL? So no, if you have employees who work out of state, they're just simply not covered for PFL. So like a lot of employers have employees that work, we'll take an office example because it's kind of simpler. You have a location in New Jersey and New York. Half of them work in New Jersey, half of them work in New York. The employees who work in New Jersey are just not eligible for New York State PFL. There's no exemption that you have to file for them. They're just not covered employees. So your PFL insurance policy is just going to cover your covered employees. The employees who work out of state are not covered. There's no exemption or anything. They don't need to opt out because they're not covered in the first place. Okay, next question here is, it sounds like private employers are required to set up an integration with their insurance carriers so employees can apply for PFL through them and get paid, for example, through New York Life or whatever carrier they have. If you're a public employer, can the employee just apply directly through the state instead of sending the PFL application to a carrier? So the answer to that is no. So public employers are not subject to the PFL law, meaning they are not covered employers. They can opt in if they choose to. They are not required to, but if they choose to opt in, they can do that. They can do this through self-insurance. They can do it through getting an insurance carrier. A lot of them choose to get it through an insurance carrier, and then it's going to work once they've opted in. It's going to work exactly like how it does for a private employer, but they don't apply. No one applies directly to the state. Like the state as an entity is not an insurance carrier, does not administer the paid family leave program. It's the insurance carriers, or if you've been an approved self-insurer, a self-insured employer who is acting as the insurance carrier. So PFL is an insurance product. The state does not deal with PFL claims unless the employer is required to have coverage and doesn't, in which case then the state will pay the benefits. But generally speaking, when we're talking about applying for leave, it's always going to go to the insurance carrier, and many public employers who opt in also have private insurance carriers. They're just purchasing a policy just like any covered employer if they choose to opt in. Okay, next question here is, can the employer require an employee to take PFL continuously? The answer is generally no. Employees have the ability to, if they're eligible, they can choose whether or when to take PFL. The only kind of caveat to that is if the employer is subject to FMLA and the employee is eligible for both, so they have the leave available to them, say for bonding leave or something, you can require those to run concurrently. So the employee couldn't take like 12 weeks of FMLA and then intermittent PFL thereafter or something like that, assuming that they have FMLA and PFL available to them for the same qualifying event. But generally speaking, the employer has no control over when an employee takes PFL. If the employee is eligible, they're going to be able to take PFL, and they're generally going to be able to choose their schedule, subject to the notice requirements and everything like that. Okay, next question here is, what if they go through the 12 weeks? When are they going to be eligible to apply again? So the maximum amount of PFL is 12 weeks in a 52-week period, and the 52-week period is a rolling calendar year. So if they take 12 weeks and then they're trying to take leave again, say several months later, the carrier is going to look back on the previous 52 weeks and see how much PFL the employee has taken, and then that's going to inform how much leave is available to them. So say it's been enough months, they took all 12 weeks, and then it's been several months, and the employee goes to take leave again, and the carrier looks back and they've taken 8 weeks in the last 52 weeks. They're only going to be able to take 4 weeks then, but it is a rolling calendar period. Okay, next question here is, can an employer require an employee to use PFL following their disability during their FMLA? So like we talked about before, if the employee has FMLA and PFL available to them, the employer can require them to run concurrently, and they can require you, like if they're taking FMLA, you can designate that time as PFL, but you do have to follow the notice requirements that are in the regulations. So that's 380-2.5 of the regulations. So there's kind of a procedure that you have to follow in order to designate it as FMLA and PFL, and then the employee does have to apply for PFL for those times. So it's FMLA and PFL running concurrently. You can require them to be taken at the same time in that instance. Okay, next question here is, does the employer size matter with PFL? So for PFL, a covered employer is a private employer with one or more employees in employment in New York State on each of at least 30 calendar days. Days in a calendar year, I'm sorry. So really that's any private employer with any employee, one or more employees in New York State. So it's virtually all private employers in New York are covered for PFL. Okay, next question here is, what about if payroll missed taking PFL deductions from the employee's date of hire? So employers are entitled to take deductions from their employees in order to cover the cost of having those employees on their PFL insurance policy, but if they don't take deductions, they aren't required to take deductions, and it has no bearing on an employee's eligibility for PFL. So if the employer just didn't take deductions from an employee, they can start going forward. The most you can go back is 1 month. You can't go back any farther. So if an employee has been employed for 8 months or something and you just notice that you weren't taking deductions, you can start going forward, but you're not going to be able to get those 8 months of deductions back. Okay, I see a few more questions, follow-up questions and other questions about localization, and they're getting increasingly more specific. So I just kind of want to reiterate that I can't provide legal advice. So I am not going to be able to tell you whether or not a specific employee in a specific situation is localized in New York. So I'm going to refer you to section 201(6) of the workers' comp law, and that has the localization test. But it is extremely fact specific. So it's not something I'm going to be able to kind of sit down with you and like figure out, okay, well, this employee does 80% of the tasks and the location of control and things like that. It's very, very fact specific, and I can't provide legal advice. So once again, that section is 201(6). So 201 and then parentheses 6 of the workers' compensation law.
Want to thank you, Courtney, as always, for taking the time to answer everyone's questions. Want to thank you all for joining us. We always appreciate your participation. Just a reminder, if you want to sign up for email updates, you can do so by going to paidfamilyleave.ny.gov. And then there's a little button on the bottom of the page that says Get Updates, and you can click on that, and that's how you get subscribed. We also distribute information via our social media channels. So along with our YouTube page, which I've mentioned, we also post information on Facebook, X, formerly Twitter, and Instagram. So make sure you're following the New York State Workers' Compensation Board there as well. Thank you all for joining us. We hope you have a wonderful holiday season and a happy new year, and we will talk to you again next year, hopefully. Thank you.